got a rise. Yes, Miss Narkin.
So I'm going to move on to the EU point and the EU arguments and to respond to my learned friend submissions on those. One of the points he made was that transfer of assets is generally movements of capital. And we would say that that isn't necessarily the case, given the breadth of the concept of and the definition of assets, and given that the transfer itself includes creation, it is capable of applying to establishing companies, to establishing trusts. It's capable of applying, as we have said, to the creation of rights such as employment rights. So it's not simply a movement of assets, being capital movements. The next point, my learned friend then took you through FII.
Yeah.
And one of the points that we would like to make is that FII is, in fact, all the FII cases are dividend cases.
Yeah.
And the point with dividends is that both the dividend is a capital movement, as in fact is the fact that it arises from something that must itself have been a capital movement, i.e. the transfer of funds into and establishing a business in, or a corporate in, an offshore entity, or in fact acquiring an interest in the foreign corporate or resident corporate in order to give rise to the right to dividends. So both are independently viewed, self-standing movements of capital. The question in those cases was, do they also, in dividend cases tends to be, do they also engage perhaps another freedom, such as establishment? Mm-hmm. Because if your rights are that give you definite control, then you may be in, then you will be in freedom of establishment, and that's what they're looking at. We are looking at a situation where what is being the principal movement is not capital. The principal movement is the employment contract. And we have support for the approach that we take from the line of authorities, starting with Louise and Carboni. Well, we cite Louise and Carboni, but also Fidium Finance, FII number 3, all of which start, well, even FII says, but Fidium Finance is not a dividend case, but reflects the same sort of analysis. You start with the legislation to look at the purpose of what the legislation is trying to do. If the legislation is capable of applying or engaging multiple freedoms, then looking at the purpose of the legislation alone does not tell you which freedom is predominantly engaged. So you then have recourse to the facts. And then that will help you understand which freedom is predominant. And on our facts, what we have is an employment contract. Services are provided under that contract. Remuneration is received under that contract. A contract of employment, we would submit, does not fall within the movement of capital. If one looks at finicking, which is in tab 59 of the bundle of authorities, so tab 59 of the bundle of authorities, if I could invite you to go to paragraph 43. That explains, having referred to Louise and Carboni, movements of capital are financial operations essentially concerned with the investment of funds in question rather than a remuneration for a service. And what we are looking at here is essentially a remuneration for a service.
But that's not what's transferred. What's transferred is the income generating asset.
What's the transfer of assets that engages the action, the movement that engages the transfer of assets provisions is the creation of the employment rights, which gives the employer the right to use the services of the employee and the employee the right to receive remuneration. And that
you're not concerned about, in this instance, you're not concerned about Mr. Hoey's right to receive remuneration, because he could do that as an employee working in the UK for a UK employer. What you're concerned about is the transfer overseas of the right to provide his services.
But it's the services as an employee, and therefore the right that is most closely engaged is the worker right.
Well, no, there's no worker right. You're not concerned with the worker right here. And he's still working in the UK. He's not working anywhere else. You're concerned with an asset. This is your case, in brackets. You're concerned with transferring overseas. I mean, you can regard Mr. Hoey and the other contractors as an economic proposition, providing services for reward. And what has been moved overseas is the right to charge for those services. And it's been done, and obviously it's structured so as you can't say, well, I didn't transfer it, I created the contract overseas. Well, you say, no, you can't say that because it's just, you've created a new contract over there, but that is effectively transferring the income generating asset overseas. And that is a financial asset. And the employer could assign that right to a third party and say, right, now you're the employer and you can have the right to the income generated from Mr. Hoey's services. And that's the asset that we're concerned with. And that's your case.
Our case is that he is providing his services as an employee under this contract of employment. And the transfer that engages the transfer of assets provisions is the entry into the contract. The rights, and that is an entry into a contract with a foreign entity. So therefore, one aspect of the engagement is that the counterparty is offshore. But what is ultimately being done is the engagement as between a worker and as between...
It's got nothing to do with the freedom of movement of workers. I mean, he's not moving as a worker. He's still working here. What is engaged is the financial asset, is the transfer of the financial asset, which is the right to benefit from those services.
The creation of worker rights, we would say, with a third party in the UK, a third party, i.e., who is not outside the UK, is a cross-border element. That therefore makes it not a wholly internal activity. What is being transferred is, or what is being created, is the ability of the foreign entity to look for his services as an employee, not for his services as a contractor, but his services as an employee. That is an archetypal worker situation, because as in return for the provision of his services as a worker to the offshore entity, he has the right to receive remuneration. That is, again, payment for that which he provides, i.e. services as a worker, i.e. an employee, to his offshore entity. That is we would submit, the analysis that is consistent not just with the facts, but with the way that we are arguing the transfer of assets provisions. Those behind me remind me that the creation of employment rights is not a movement of capital or rights or assets for EU law. And if one also looks at the legislation, the nomenclature to which is not intended to be exhaustive, but is quite detailed, it does not cover employment rights or the transfer of employment rights. It's legislation bundle, tab 12. I'll let Brenda take you to it. It is looking at
I think that's because it's very unusual to look at an employment contract in the way that Mr. Justice Hoffman did in bracket. And if you look at an employment contract in that way, and carve up the rights in the contract in the way that's looked at, in a way that isn't normally done in relation to employment contract, you can see that the rights being talked about there are very much akin to other rights for receiving income, such as an author's right to to payments for exploiting their work.
And an author's rights would be a self-employed activity, one would say. We're looking here at an employment activity. And an employment activity...
We're looking at the employer's rights, aren't we?
Well, the transfer of the rights is by the creation of the rights to provide his services, or the obligation that is created as a result of the employment contract to provide his services to the employer, with the employer's mutual obligation to him to provide remuneration for that, we would say, is the transaction that has taken place here. So the assets that are being held, the thing that can be turned to account, is the ability to use Mr. Hoey's services for the purposes of fee generation in the hands of the employer. But those rights are worker rights, i.e. the rights to use a worker's services. Yeah. And the point is that just because the transfer of assets provisions deem something to be a transfer, a creation to be a transfer, there is not as such a transfer for the purposes of movement of capital for EU purposes. So the deeming that occurs for the purposes of the transfer of assets provisions is a deemed, and it is an autonomous UK concept. It's not an EU concept. The next point to which I wished to take you was my learned friend's reference to FII number 3 and where it was said that they could rely on the FMOC even in relation to a third country. And we say that the essential distinction between the dividend cases and cases such as this is that one applies a different analysis, because in dividend cases, each dividend, each direct investment that gives rise to the dividend, or the right to receive the dividend, is a free movement, is a capital movement in its own right. And therefore, it does need to be analysed to see whether or not it is a movement of capital per se, or whether, in fact, it could be regarded as something that engages the freedom of establishment, because there is enough of an interest acquired in the other entity. Whereas when we look at the transfer of assets provisions, they engage not just establishment, as we saw in Fisher, but they also engage other movements. They could, in fact, just be a simple movement, or perhaps the setting up of a trust or a company offshore. If it's a company offshore, it would be establishment. If it's a trust, it might be services, or the right to receive services. It depends very much on what is being created, which falls within the concept of transfer of assets. And then, if one looks at the essential point that my learned friend was making, which is that if there is a movement of capital, you can give independent analysis and independent force to that movement of capital and attach the freedom protection to it. And we say that doesn't flow, given not least FII number 3, which is the dividend case, but also the analysis in non-dividend cases, such as Fidium Finance, to which I took you in my main submissions, and Finicking. That brings me to the next point. My learned friend said, well, Louisian Carboni, it's not really been cited very much, it's not good law, and we beg to differ very strongly on this side of the room. Aspects of Fidium Finance, so paragraph 16 has been most recently cited in a case. Sorry, yes, my learned friend reminds me that you don't actually have copies of Louisian Carboni, so perhaps...
It was referred to in Finicking. that you just took us to at 43.
Yes. So in Finnecane, we've got citations to Louise and Carboni. Yes. And Louise and Carboni itself has just been handed up to you. And Louise and Carboni, the facts, if one looks at the second of the two paragraphs in the head note, services, movement of persons, money, medical treatment, education, the freedom to provide services includes the freedom for the recipients of services to go to another member state in order to receive a service there without being obstructed by restrictions, even in relation to payments, and that tourists, persons receiving medical treatment, and persons travelling for the purpose of education or business are to be regarded as recipients of services. That's what paragraph 16 dealt with. And then the next bit is the money, capital, investments, payments. The general scheme of the EC Treaty shows, and a comparison between Articles 67106 confirms that current payments are transfers of foreign exchange which constitute consideration within the context of an underlying transaction, while movements of capital are financial operations essentially concerned with the investment of funds in question rather than a remuneration for service. And for that reason, movements of capital may themselves give rise to current payments, as is implied by 67.2. And if I then take you, you will see the facts are set out on page 3. But I've taken you to the part of the head note which gives you, I think, a sufficient background for current purposes. If I could then show you paragraph 16 of the judgment, which starts at page 13 of the clip you've just been handed up. The bottom of page 13, and then over the top we've got the facts again recited on at pages 13 to 14 and 15, and then at page 16 it deals with the first point about provision of services. And then the next part, that paragraph has been cited.
Sorry, which paragraph are you asking us to focus on?
Well, 16 was to deal with the services point. This goes to whether or not Louisian Carboni is still good law, because my learned friend asserted that it hasn't been cited recently. Paragraph 16 has been cited. I didn't want to mislead you by saying Louisian Carboni itself has been. Paragraph 16 has been cited in a case C311/19 Bomver Win. And it cited it at paragraph 18 of its own judgment. And of course, we've seen that the passages below in Louisian Carboni, so paragraphs 20 through to 22, forgive me, 23, form part of the background and reasoning in Finnecane. And Bomber Win is December 2020. My learner junior must have helped us. And to make good the point about Louisian Carboni and paragraphs 20 to 23 being cited in Finnecane, if I could ask you to look at Finnecane, which is tab 59. The point being that, given that it's cited in Finnecane, if there were any problems or concerns about the validity of Louisian Carboni, that was been dealt with, and they haven't. And as my learned friend reminds me, the fact that a case has not been cited by name does not mean that it's not good law, not least, my lady and my lords, given that its analysis is consistent not just with paragraphs 90 through to 94 of FII number 3, but also with Fidium Finance at paragraphs 25 47 and 50. 47, 48 and 50.
Would it be right to say that Louisi and Carbone was a Grand Chamber decision, or did they have that distinction back in 1984? And I see there were 9 judges sitting. Is that right?
May I just confirm?
Yeah. Or maybe it's 8.
My lord, we're not entirely clear about that.
I wasn't either. That's why I was asking.
There's certainly a full bench.
Well, it's certainly a full court. I mean, it's a time when the community didn't have all that many member states.
Quite, my lord. I'm afraid we can't give you any further assistance, my lord. Lots of commentary, but I'm afraid no great assistance.
Well, that's a little conundrum. We can follow up if we wish to.
My learned friend also referred to the Fisher case, and what we would say in relation to the Fisher case is that it concerns freedom of establishment. Freedom of establishment doesn't have the expanded meaning of wholly artificial arrangements that we now have as a result of ex-GmbH in where free movement of capital is engaged. So when reading Fisher, clearly you will have that in mind when looking at what is considered to be wholly artificial arrangements in that context. I believe my learned friend acknowledged that it is capable for the motive defence to be read down in the manner in which we have suggested, so that it is consistent with ex-GmbH, the primary objective, or one of the primary objectives, for which I'm grateful. He then took you to, and in relation to the example given in ex-GmbH, my lady, you have our submissions on that point, and they are consistent with what you said to my learned friend, which is that the example set out in ex-GmbH in that paragraph 87 or 84, I believe, is an example. So there are other examples equally possible. My learned friend then took you to Lexel, of which you do have a copy. And Lexel itself concerns freedom of establishment, not free movement of capital. And again, therefore, the same point we make in relation to it needs to be borne in mind, which is that it is the ex-GmbH meaning of wholly artificial arrangements that is relevant. And if I could just ask you, the other point about Lexel is that it postdates the Withdrawal Act, such that, while persuasive, it isn't binding on this court. And if I could just ask you to look at paragraphs 20 to 22 of the Lexel report. Might I just ask you to cast your eyes over that?
21 and 22.
20 through to 22.
20 through to 22.
point we'd ask you to note there is that the sort of arrangements that are being considered in Lexell are, it's not 100% clear whether they were in fact wholly artificial arrangements. Our premise here and our submission here is that what we have, that we are tackling here, are wholly artificial arrangements, a scheme set up in order to pay remuneration in a non-taxable way to, in a way, a non-taxable way as to a large part of the loan. And that is, we would say, a material difference anyway. So to the extent that it is that this case is said to concern wholly artificial arrangements, we say the quality of the arrangements in Lexell are entirely different to the sorts of arrangements that are before you in this case, which we say are wholly artificial. And then if I could just ask you, you had asked me yesterday about, I had said that I would bring along copies of the amended legislation in the light of 2013 and those amendments. And my learned friend is just going to hand those up to you now. I might just have a moment on my lady. So, my lord, you will see, and my lady, you will see that section 720. So 721 was amended. Of course, there have been lots of amendments post 2017, FA 2017, to deal with protected foreign source income and the like. But the relevant changes that we're looking at are the changes at 3A, B, C, and the removal of subsection 5A. And the importance of the removal of subsection 5A, if I might invite you just to go back to the legislation bundle. To tab 8A. If one compares the 721, one sees it as amended, you see that 5A is missing.
Well, it's 5 little a. Is that?
5 little a is missing.
5 capital A. Yeah.
Yes. Forgive me, my lord.
No.
So what that does is it takes away. Paragraph 5 starts. It does not matter for the purposes of this section, A, whether the income would be chargeable to income tax apart from section 720. And of course, alive to the double charge issue, that has been removed. You will see that. Subsection 5 no longer contains that. It only contains B and C. And then, if one looks at 3C, 3 capital C above it, subsection 1, that is the charging subsection, does not apply if the individual is liable for income tax charged on the income of the person abroad by virtue of the charge not contained in this chapter and all that income has been paid, income tax has been paid. I, of course, recognise, my lord, that that income point still arises. And issues of that sort are being actively considered. Is my understanding, If I could invite you, however, to take a look at the explanatory notes, which I believe have also been handed up to you in that little clip. The explanatory notes, FA 2013, and to these changes made therein. On the last page of that, you see that the aspiration is to avoid double charges. So paragraph 58, which is the penultimate paragraph, there is an amendment to provide greater clarity around the prevention of double charging in circumstances where the same income could be the subject of both a transfer of assets charge and also a charge under another part of the tax.
I mean, that is true double taxation, whereas what this doesn't address is the sort of economic double taxation, which would be the result in this case if the revenue were right.
My lord, we've heard all your,
I just want to be sure that you're not submitting to us that aspect of the matter has so far been dealt with in the legislation.
My lord, I'm not in a position to say that it has been dealt with.
No, thank you. I just want to be clear as to what has and hasn't changed. But you say these amendments do at least show that the point about the position where there could be true double taxation of the same income twice over has been addressed.
Yes.
And yeah, thank you very much.
And a similar change has been made to section 728 as well, just for clarity. So that, my lord, brings us to the final point that we'd like to make, which is if the court is against us on wholly and exclusively, and if the court is against us on power to enjoy, then no double charge could arise in these appeals at all. In any event, Mr. Hoey and the other claimants and followers, the amount of tax payable under their closure notices and discovery assessments was the IT amount. And the FTT was not asked by HMRC to increase the amounts to reflect any separate charge under the transfer of assets provisions. As to the other cases, those behind us have obviously taken careful note of what it is, of your observations, and will give proper consideration to what powers prerogative or otherwise, interpretive or otherwise, not prerogative, interpretive or otherwise, may appropriately be exercised to address that situation. However, we're not in a position at this moment to say what form that will take. There are many stakeholders, they do need to be consulted in order to make these changes.
Well, I quite understand that, and it's not the kind of decision that wants to be taken in a hurry without a proper opportunity for consideration.
Absolutely.
And also, speaking for myself, I mean, although we've been putting a lot of observations to you, and I'm glad to hear they are going to be carefully considered. I mean, they are at this stage observations. They're not yet any. Well, remains to be seen what we say in our judgment.
That certainly remains to be seen.
Yes.
May I just consult those behind me to see if there's anything further to be? My lord, my learned junior, Mr. Lemos, reminds me that you had indicated that you'd like to receive in electronic form everything that's been handed up.
Yes, I was going to make that point.
Yes.
If possible, could we have electronic versions of all the extra material, legislative and case law on both sides? Could we have that electronically?
Absolutely. Mr. Hurajiwala and Ms. Lemos have been keeping a running account of all the things that have been handed out.
That's very
Able to
helpful.
put together a bundle and make sure that you receive it.
That'd be very helpful. Thank you.
Thank you. Those are our submissions.
Thank you. Thank you, Ms. Nathan. Right.
My lady, I appreciate it's been a long week and I'll try to be very, very brief. Firstly, can I just apologise if I suggested that Luigi and Carboni had never been cited? That was obviously wrong. What I meant to say was that it had never been cited for the proposition which hadn't been cited for the proposition which has been relied upon, so far as I could see, since the Persia case. And apologies if that wasn't clear. On condition C, which my own friend referred you to, just two very brief points.
Yeah.
Firstly, if it said we have related money, that has to be for the purpose of providing a benefit. Query whether paying somebody their full salary is a benefit. And it has to be as a result of successive effects on the income. But as we've discussed, you don't get the income until you've had the profit. So the payment has been made before you've had any income. So
It's the same point you made in relation to all the...
Yes, but also it should be noted that section 724 applies where we're dealing with condition C, and that's on page 458 of the bundle. Subsection 2 says that you're liable to income tax under that section for the tax year in which the benefit is received. But then subsection 3, but subsection 2 does not apply so far as it is shown that the benefit derives directly or indirectly from income on which the individual has already been charged income tax for that year or previous year. So the fact that it's provided out of a benefit on which he's chargeable to tax provides a complete answer to condition C. Section 724. And that is all I have to say on it.
That's very helpful. Thank you. Thank you, Mr. Mullen. Well, thank you. Thank you all. You looked as though you were about to stand up to speak, but that was
No,
just...
I thought you were going to stand up, so I was going to stand up too. No.
Thank you all, not only to those who had speaking parts, but we know that those sitting behind will have contributed enormously to the volume of material we have before us. We've been greatly assisted by you all. We will be reserving our judgments. They will come to you in the normal way for typos and the like, nothing else. Please remember the embargo that has been emphasised recently in a number of cases. The opportunity to produce typos and the like is not an opportunity to re-argue the case. I know you all know that. But it may be that having seen our judgments, you will be able to agree the terms of consequential orders, and it, we hope, won't be necessary to have any further hearing. We are all grateful.